To everyone entering the webinar now, we're going to wait just maybe 1 or 2 more minutes to let people join, and then we'll get started. Hi, Danielle.
Hey, Mark, how are you?
Good. How are you?
I'm good.
Good to hear. Well, I think we'll go ahead and get started. Welcome, everyone. This is the Special Education Legal Clinic. I'm going to share my screen here, and we'll go ahead and get started. All right. Can you see that?
Yep.
All right. Well, like I mentioned, this is the Special Education Legal Clinic. This is a collaboration between Albite Weicker LLP, Disability Rights Ohio, and the Ohio Coalition for the Education of Children with Disabilities. And this is Understanding FERPA and Student Privacy today. I'll be leading the workshop, and all of you most likely registered through the URL at the bottom of that slide, lawyersforstudents.com/legal clinic. We have a few other workshops following this one in the series, and those are extended school year, so ESY in March, Understanding Autism by OCECD in April, School Choice for Special Education Parents by Albite Weicker in May, Procedural Rights and Dispute Resolution in June, and then New Parent Notice Requirements by Tammy Sebastian at OCECD in July. And we'll be, in the next few months, we'll be figuring out what our next series will be. But this one today, again, is Understanding FERPA and Student Privacy. A couple, I guess, procedural points before we get started. You can drop any questions, ideally in the Q&A, and then we'll try to stop occasionally and answer those questions, or maybe Danielle help me out and let me know there's a question pending. And then if we have time at the end, we try to keep maybe anywhere between 5 and 15 minutes at the end of the workshop to open it up for questions generally. Me and Danielle are here. There may be some others from Disability Rights Ohio or Albite Weicker joining us as we continue. But by all means, questions about the workshop during the workshop, and then really open for any questions at the end. For anyone who's scheduled for an individual guidance session, those will happen between 1 and 3 o'clock after the workshop. And to schedule an individual guidance session, anyone could do that for 30 minutes privately with an attorney and advocate. Those you can schedule at the same place, which is that URL at the bottom, lawyersforstudents.com/legal clinic. And that's also where you can sign up for any of these workshops upcoming if you haven't already. So Without further ado, I guess I'll get started with understanding FERPA and student privacy. This is a topic, of course, important to students and parents, but just as important to educators. And it's important because number one, for parents, it is important to know what you have access to and what you don't, and then what third parties have access to and what they don't. So that's what we're going to talk about a little bit here. The primary piece of legislation that we're going to talk about is FERPA, which is the Family Educational Rights Privacy Act. And that is, like I mentioned, a federal piece of legislation that governs what schools can do and what they can't do with school or children, student education records. So leading up to FERPA, so we're talking about almost 50 years now. It's been since FERPA was adopted. This was in August 21st, 1974, became effective later. But so coming up on 50 years, it's important to recognize, I guess, the environment leading up to FERPA. Privacy was in the minds of a lot of Americans. There was a big piece of legislation that was passed the same year. That was the Privacy Act of 1974. And that determined or governed what federal agencies could do with the personally identifiable information from federal employees. Another thing that I guess put privacy on the forefront of people's minds in 1974 is that FERPA was adopted, like I mentioned, on August 21st, and Nixon had resigned on August 9th. So 11 days difference between Nixon resigning and President Ford then signing FERPA as into law as a piece of legislation. And this was drafted in response to the growing evidence of the abuse of student records across the nation. Senator Buckley was the sponsor, and you can see there a picture, a co-sponsor of the bill was a young Joe Biden. And the question that everyone was asking in the mid-70s was, what is the government doing with our data? So as employees of federal agencies or political subdivisions, what's the government doing with the information that they collect from us as employees or as students of a public school district? What is the government doing with the data or the education records that they maintain on behalf of the students who attend public schools? So that was the environment leading up to FERPA, and the question that a lot of people were asking. It's important to understand because a lot of parents in particular conflate public records versus education records. And it's important to recognize where FERPA fits in. So if you consider with public records, so there's in Ohio in particular, there's a revised code section 149.011. This is that defines what a record is, what a public record is. And that statute 149.02 gives individuals, any citizen, the right to request public records. So a public record is just a record that's stored on a fixed medium, so on paper or electronically or some other medium, and then is created, received, or sent under the jurisdiction of any public office. Let's say, for the sake of the example, the Department of Education. And then it documents the organization, functions, policies, decisions, procedures, operations, or other activities of the office. So in short, that definition is really any information received, sent, that's on any medium that is maintained by the public agency. That's a public record. And that's important because that means that that's accessible or should be accessible, with some exceptions, to anybody, any citizen of the state. So a lot of records that are maintained by public agencies, including schools, are public records. One good example of that is a personnel file of a teacher is a public record, with some exceptions, and those being like workers' compensation records or medical records that might be in the file. Those are not, those are exceptions. Social Security numbers is an exception to a part of a public record. But by and large, public records that's the big umbrella that's available to anyone at any time, just upon a request, a public records request. Well, FERPA, or student education records, are an exception. So you see an exception to public records, the release of which is prohibited by state or federal law. Well, FERPA makes education records an exception to public records. So no third party can just request the student education record and receive that, because it doesn't fall under a public records request. And that's important to recognize. So what does FERPA do? And I see I had a question here, so let me just double check that. Yeah, good question. So the question is, FERPA only applies to records, correct? Yes, that's an important distinction. And we're going to talk a little bit more about that, but FERPA in itself only applies to education records. So records maintained by the school that contain information about a student, which we'll talk about that definition. It's important. It does not include like observations or information that is discussed, generally in the classroom. So very good question. We're going to get to that a little bit more specific on that answer in a second. But the two main components of FERPA, it's important to recognize that number one, it guarantees access to students and parents. So if the school maintains records on that student, that could be grade cards, that could be an email from mom or dad, that could be anything related to the student. The student and parents have access to that information. So affirmative access. If you think about before FERPA, you could request that information from the school, prior to 1974, request that information from the school, but they didn't necessarily have to give it to you. And by the way, that's true largely for private schools today. FERPA only applies to public schools or schools that receive federal funding. So, for a private school, as it stands today, although most of them do comply if you ask for education records, there's no law that requires a private school to give you education records like there is for a public school. So the guaranteed access, you'll see in the red on the left, there are exceptions based on the definition of education records. So you only have a right to education records. And we'll talk about that definition, and we'll talk about the definition of student and parent. So you have to be either a student or a parent to have that guaranteed access. And then the other main component of FERPA is that it limits access to third parties. So no third party can just request the education record of Johnny Smith and have access to that. But there are exceptions, 17 major exceptions that allow the school to disclose education records to a third party, which we'll run over. So the two big parts, there's actually a third component to FERPA, which we use on occasion through our law office, which is the third major component is FERPA actually gives you a right to request amendment of the records. So if there is arguably inaccurate or misleading information in an education record, the third component allows you to request that the school amend that or remove that record from the child's cumulative file. Or if they disagree that it's inaccurate or misleading, ultimately the student or parent can place a statement in the file identifying why they disagree with it. So there's a largely unused third component of FERPA, but it can come in handy when there's inaccurate or misleading information in the student education record. All right, so what is considered a parent and what's considered an eligible student? So these definitions are important because you only have a right of access if you're a parent or eligible student. And then one exception to providing student education records or personally identifiable information within an education record to a third party is, of course, the school can get consent. And if any of you are parents, you've probably consented a time or two for that information to be provided to a third party. So the right of access only applies to parents and eligible students, and the consent can only be given by a parent or an eligible student. So the parent's definition is a natural parent, guardian, individual acting as a parent. So someone who's standing in as a parent. It doesn't necessarily have to be, documented through the court. It doesn't have to be a guardian. It doesn't have to be official. If the school determines that someone is acting as a parent, even as in a temporary capacity, they can provide a right of access to the education information, or they can allow that person to consent on the student's behalf to provide it to a third party. Once the student turns 18, the rights transfer to the student. So then the student would have to provide consent, except that this is a big exception too. If the child remains a dependent, then the parents retain a right of access for a dependent, and that's a dependent for IRS tax purposes. So if the parents can show that they've claimed the son or daughter as a dependent for IRS tax purposes, then into college, the parents have a right of access to the education records, which you can imagine why that would be important, especially if they're paying for college. And then eligible students. So I mentioned the rights transfer to students at age 18, or if they attend a post-secondary institution at any age. So this comes up when a student is attending or they're using the post-secondary option or college credit plus. If they're attending college classes while they're in high school, that college will most often treat them as the consenting party or the only party who has a right of access to those records. Again, unless the parents can show that the child is a dependent for tax purposes, in which case the college should provide access to the parents as well. All right. So this goes to the initial question that was asked about, does FERPA only apply to records? Yes, it only applies to records, not observations, not conversations. Sometimes it applies to videos. We'll talk about that. But education is defined as records, files, documents, and other materials which contain information related to a student and are maintained by an educational institution. So it has to have information on a student, has to be maintained by an educational institution. Again, the definition is important because if it doesn't contain information related to your student, then you don't have a right of access as a parent to that information. Now, keep in mind that an education record is an exception to the public records law. So a lot of times, even if you don't have a right of access to something that you deem an education record, if it's not an education record, it's very likely that it'll fall under the Public Records Act, in which case, as a citizen of the state, you can request that. It gets a little confusing, but if you just consider the public records law as the big umbrella, and then education records as a component of that, which are records that contain information related to a student and are maintained by an educational institution. The maintained by an educational institution part comes into play because it has to be held in kind of a central file. There's a case where they determine this pretty early, and it can be electronically or on paper. The file has to be maintained by the school, not necessarily only by the teacher or by a teacher's aide. It has to be maintained by an educational institution or housed in some way electronically or in a physical file. Okay, so far so good. All right. So prior to FERPA, or I should take this back, early on in FERPA, they actually had kind of a laundry list of items that were considered education records. It's before they adopted that definition that I just provided you, that one there. It was about a year later, I think they adopted the more broad definition of containing information related to a student and maintained by an educational institution. There used to be kind of this laundry list, and some of those things were academic work, test scores, attendance records, IQ tests, psychological tests, behavior reports, observations, classes completed, class rank, all things that contain information related to a student and are maintained by the school district. But instead of creating this exhaustive list, it was suggested and then ultimately adopted that FERPA just have a definition like this one. So there's no more laundry list. But this is a good example of things that would be considered education records. So through the years, they've also had cases or decisions by the Department of Education to help us understand what things are not education records. And these all go back to the definition. So if you consider that teacher, counselor, personal notes, they are not education records because they're not maintained by an educational institution. So that only counts. Like a lot of, let's say, lesson plans, for instance. First of all, it may not have information directly related to a student, but that lesson plans are typically provided from the teacher to the school. So they would be maintained by a school. But when a teacher just makes notes for themselves, and the definition here, or what's considered not an education record, is when that particular document or record is in the sole possession of the maker, SPOM. So if it's only in the possession of the teacher, it doesn't go on to the office, it doesn't go into the student file, then that's not considered an education record. And sometimes we have disputes about whether or not teacher notes are actually education records, which the parents would have access to. Law enforcement records. Now this one, there's an important distinction. Law enforcement records for an agency that's not connected to the school. So if we're talking about campus police, well, that's still an education record because it's the police department is considered a component, or I'm sorry, an agency of the school. If we're talking about law enforcement records for the sheriff's department, which has no connection to the school, in that case, then they're not education records. So you don't necessarily have a right of access as a parent to those law enforcement records. However, many of those law enforcement records are public records. So as a citizen, assuming there's no pending investigation, a lot of times you can get law enforcement records by making a public records request. But the school doesn't have to give you those because they're not in the and they're not maintained by the school district. Personnel records, I mentioned, well, it doesn't have anything related to a student most often. However, sometimes there are personnel records that do have information related to a student. For instance, like if there's an investigation done or a witness statement in the file, the personnel records may have a student name on the records. So you could do a public records request for a personnel file and ask that any student confidential identifying information of students be redacted from that record and get a copy of a witness statement. Or if let's say your child gives a statement and the only child identified, only student identified in that statement is your own, then you would have a right of access, assuming the school maintains that record and it contains information related to your own child. Then it's an education record because it fits the definition. Gets a little confusing, but between the public records law and FERPA, you can typically get a copy of a file. We'll talk about redactions in a minute. A lot of times redactions could be made from a record so that it removes personally identifiable information from other third-party students, in which case you can get the file so long as that student identity is redacted sufficiently by the school district. So this comes up in incidents or fights at school, or disciplinary incidents where more than one student's involved, where you're trying to get a statement of what happened, and there might be 4 or 5 or 6 or more students identified in the record. Well, the way you would have to do that is request the record as an education record. If it contains information on your student and it's maintained by the school, then it's an education record, but you'll have to request that with redactions of any other students identified in the document. And then the school should provide that with the redactions. Another thing that courts have decided are not education records, treatment records of college students. So a lot of times college students will go to the health center at college, or maybe they receive treatment at college, and in particular treatment records they've decided are not education records. Those are confidential medical records that are maintained by the health agency or the health center at the college. Now, alumni records, this one gets confused a little bit. Alumni records, so records that are created after you graduate from a particular school, high school or post-secondary. Alumni records are not education records because they don't fit the definition. However, your records from when you attended an institution are education records. So if it was created when you attended, it's an education record that's protected against disclosure to third parties, and you have an affirmative right of access to get those records. But things that are created, let's say if you're on the alumni board or you're participating as an alumni volunteer in some way or involved in the school, alumni records are not protected by FERPA from third parties, and you don't have an affirmative right of access to those records. This was just a very unique situation in number 6. Student graded papers. This was the Owasso case. Very early on in FERPA, you did the teacher did the thing where they, you take a quiz and then you exchange papers, and your neighbor student here grades your paper and then you swap them back. Well, this surprisingly went to the Supreme Court, and because the parent claimed that was an education record, or it was a violation of FERPA because one student handed their paper to another student, and that made them privy to the student's own education record. Well, the court said because they were not maintained by the school, makes sense, right? Those were just exchanged back, never turned in or maintained in a file for the student's grades. Those student graded papers did not ultimately become an education record because they were not maintained, in some central location by the school district. And then this also answers the question that we had earlier. FERPA only applies to records. That's important to understand. This came up a lot during COVID, in that, we were all kind of semi-watching what was going on in our children's classrooms while we were on Zoom. And other parents were watching in, and each of our kids were raising their hand or volunteering an answer or participating in the class discussion. Observations are not records. So just like you can go in and observe a class at any time. Most districts will allow you to do that. You sitting in the class is not a FERPA violation because you're observing what's going on in class. Now, if the teacher was standing in the front of the room reading off of an education record, disclosing information about your student, that would be a FERPA violation. But if you're just participating in a discussion, observing those discussions either virtually or in person is not an education record. And there was lots of beef about that coming up, like I mentioned, during COVID. There is one situation that comes up where if a teacher, let's say a teacher or a guidance counselor, documents their observations. So they're observing, Johnny in class again, and they write down what they observed, or they document an incident that occurred. Assuming that document is not in the sole possession of the teacher, it ultimately, let's say, goes to the principal, or gets placed in a file, or is used in consideration of discipline, or in consideration of a behavior plan for that particular student, or added to the special education record of that student. Once it's written down, it becomes a record. So even if it's observations that are recorded, in that case, now we're talking about an education record, most likely, again, if it's maintained by the district or used for discipline in any way. Okay. Now this, when we give this presentation to districts, is very important. So school administrators, in particular principals and records custodians for districts, have to know what the exceptions are to allow disclosure to third parties. And there are a lot of them. Some of the ones that you might know of. So, if Johnny is on a behavior intervention plan, or if Johnny has an IEP, that information has to be provided to employees of the district who have a legitimate educational interest. So if Johnny's not in band, you don't necessarily need, and you shouldn't, give the IEP or 504 plan or behavior intervention plan to the band director. But if Johnny's in science, then the science teacher should absolutely have a copy. So there's an obvious exception for employees with legitimate educational interest. When you transfer schools, the schools can automatically, under state law, provide the education records to the school that the child is transferring to. To Department of Education, representatives for legitimate documenting reasons for where the child attends school and how they're doing state testing, for instance. Most of the data that's provided to the State Department of Education is disaggregated, though, so that the student identities are not included. So for financial aid, now subpoena is a big exception as well. So, if there is a lawsuit, then a third party can subpoena education records, and so long as the school district gives you notice that they're going to provide the education records to this third party pursuant to a subpoena, and they give you time to quash the subpoena, which is up to 45 days, then the school would have to give the education records to the requesting party pursuant to the subpoena. So that is an exception allowing disclosure. To juvenile court officials, for the testing studies or improving instruction. This is for agencies they work with to improve the educational instruction or the academic instruction in the school district. For accreditation purposes, to parents of dependents, like I mentioned, that's one of the exceptions. To health and safety personnel during an emergency. So yes, schools can provide in the case of some type of emergency. It could be a COVID outbreak, by the way. It could be a school shooting. It could be any situation for a limited amount of time to health and safety personnel during an emergency. And the scope of that release is only what's necessary to help abate the emergency, and only for that limited amount of time in which the emergency is taking place. Some, again, common sense exceptions. Final results of discipline of a victim of sexual assault, a crime of violence or sexual assault. That's most likely in post-secondary institutions where a victim wants to know what the final results of discipline against the perpetrator were. To parents of a student who violate the alcohol and drug policy, and again, if the student's under 18, you have a right already in K-12 schools. So this is something that applies post-secondary again. Sex offender registry, U.S. Attorney General for terrorism-related issues, and then focus on the last two, to any party with redactions. So again, I can request an education record so long as my student is identified in the record or it pertains to my student, even if other students are on the record with redactions. So you identify any information that would reveal the identity, not you, but the school would redact any information that would reveal the identity of any third-party students. And then you should have access to the record because it's an education record of your child as well. In directory information, this is a commonsensical exception, and you may have wondered in the past, well, how do they publish a yearbook? That's personally identifiable information of students that's maintained by the school district. That's right. But there's a common sense exception for name, courses of study, the grade you're in. Of course, the yearbook says these are sophomores, these are juniors, these are seniors. What programs you participate in, band, basketball, any of those things. So what you would consider in a yearbook is considered directory information, or what you'd consider in a playbill, for instance, for a play, is considered directory information. And the school's requirement in that regard is to publish their categories of directory information in their policy. And then parents have the opportunity then to opt out on an annual basis. If you don't want to be in the yearbook, you don't want that information, the directory information, published in the yearbook or in the playbill or anywhere else, then parents can opt out and have that directory information for your child excluded. And then there's really a couple bonus exceptions. Consent is always an exception. If the parent consents or the student consents, the student after 18, parent under 18, if consent is always an exception. So if somebody requests the information and you provide consent, then that's an exception. By way of example, any of our clients, if they're students, we have to send in a FERPA release form or FERPA consent form for those, for us to be able to have conversations with the school and then request any education records. They give consent so that us as their attorney can access that information. And then bonus number 2, anything that's not an education record, like we said, if it doesn't have information pertaining to your student or it's not maintained by the district, then it doesn't, doesn't fall under FERPA. And I saw a question pop in. Let me just see if I can answer that now. It is the school's responsibility. So the question is it the school or parents' responsibility to distribute students' IEP to non-homeroom teachers? The school should absolutely do that. Now, that doesn't always happen. So as a parent, you might want to be proactive and do that yourself. But absolutely, to the extent that IEP or 504 plan or behavior plan, anything attached to the IEP pertains or that particular student needs an accommodation or specially designed instruction in that class, or even extracurricular, that information should be provided to those teachers. And Danielle, did you have to?
I was in the middle of typing the answer, so I'm sorry. You got to me before I was able to submit the answer, but yes, I was just going to agree that it's the school's responsibility. I think the accommodation section on the IEP is imperative for general education teachers to know, because that's when those accommodations take place. And I was just going to suggest to that individual who asked the question, if you are worried that the gen ed teachers don't have the IEP, then certainly bring that up as soon as you are aware that they didn't see that, because you certainly don't want those accommodations or services to not be provided in the classroom. So,
yeah, 100% agree. And if you have any doubt, I would either request that it's distributed to all the teachers and again coaches, or do it yourself. It's not, if you just want to make sure it's done, sometimes you can do it yourself. All right, another question. What if a school shares a child's medical records that were in the school's possession with a consultant, and the consultant's report serves as a school's evaluation for an ETR, but the family did not authorize disclosure of those records to the consultant, and the parents weren't included in the eval, nor was the child's medical team, and there are medical impacts of the consultant's recommendations. So this is going to depend on whether the consultant is a contractor with a legitimate educational interest. So if you've consented to the consultant in some way, then the school is going to argue that it's a contractor with a legitimate educational interest. That can happen. It's just like an employee with a legit educational interest, but there would have to be a authorization on the part of the parent to say, yes, we would like to use this consultant, or we agree to the evaluation by this consultant. I'd say if it's just provided to a third-party consultant that the parent had no input, then that's probably at least arguably a FERPA violation to provide that information. So, and with medical records in a K-12 school, those are considered, those are protected by FERPA. Yeah, I think that could be a problem. And we'll talk about what happens when there is a violation of FERPA and what you can do about that. But I'd say if there was no agreement to use the consultant or have the consultant do an evaluation, I think implicitly, if you say, yes, we'll use the consultant for the evaluation, then you're at least implicitly authorizing the school to share educational records with the consultant. But if that didn't exist, I would say that that's a FERPA violation. Yes. Okay. Let me get back to the slideshow. Just right on time. So if there isn't a violation, so first I would address it with the school, say that you think it is a violation of privacy under FERPA. There's also a state law that applies, I'll talk about in a minute. It's really a parallel state law in Ohio. So it's either FERPA or the state law 3313, 321. and both would prohibit, providing education records to a third party without consent or without an exception. So who enforces this? First of all, I'm going to jump right to the bottom. This is an unfortunate reality for some, but there is no private right of action. You can't sue the school for a violation of FERPA. There are other privacy rights that can be infringed upon, in which you could sue the school if it came to that. But in regards to providing an education record to a third party without consent or violating FERPA in some other way, not giving you the access to the records that fall within the definition, the enforcement comes through the U.S. Department of Education Student Privacy Policy Office, so SPPO. And you have to allege a violation within 6 months. It's a relatively easy form to fill out at their website. And then they determine whether the school violated FERPA, and the more stringent or the more difficult standard to meet is whether the school has a practice or policy of violating FERPA. So if they did it once and it was a mistake, they're not going to find a violation. But if the school does this on a regular basis, for instance, if they on a regular basis without consent provide education records to a consultant, then that would be a practice or policy of violating FERPA. And then they give a remedial period. So the school allows the U.S. Department of Education allows the school to fix it and offer ways that they're going to fix it in the future. And then if there's continued non-compliance, then there's some options for the agency. They can withhold further payments, federal funding. They can issue a cease and desist letter, or they can terminate federal funding altogether. But there is no private right of action. So there's not a lot of teeth to the law in that regard, but a violation can be alleged. You can identify a violation to the school if you just in regards to identifying that they are not compliant with the law. And then of course you can identify the violation to ultimately get access to the education record. But no way to sue for money damages against the school who violates FERPA. And another point, which is very important, is that students and parents cannot violate FERPA. FERPA only applies to federal funding recipients, so that's schools. FERPA does not apply even to school employees, although if they're acting in the scope of their employment, they're acting on behalf of the school. But technically, it only applies to the school itself, the federal funding recipient. So, it happens in hearings all the time where one student will say another student's name, or they post information online. A student or a parent cannot violate FERPA. And even if they did, the only enforcement is to take away federal funding. So again, we're not federal funding recipients, so we can't violate FERPA unless you're a school. Next, and though you'll see if you file a complaint at the SPPO, you can only file that against the school itself, not against individual employees, although they are responsible for how the school behaves. All right, let me check these questions here. Good question from Rachel. Does FERPA apply to private schools if they accept federal or state funds via scholarships? If a private school accepts federal funds, then FERPA will apply. Yes. So not state funds via scholarship. So if they're a John Peterson provider, that doesn't work to make, they are not bound by FERPA in that regard. But if they accept federal funds, some schools, for instance, some private schools accept federal funds for free and reduced lunches. Some accept federal funds for transportation. Some accept federal funds for other reasons. But FERPA, if they are a federal funding recipient, then it will apply to a private school. Next, what if a school shares a child's, oh, I'm sorry, I read that one already. I hope that answered the question, Rachel. If not, feel free to type some more. All right, I mentioned that Ohio has a kind of parallel law, that's 3319, 321. And This is the state law parallel. One difference, Ohio in 2020, there was a case decided called Cable News Network versus Bellbrook Sugar Creek Local Schools. Interesting case for a few reasons. Number one, they're determined, FERPA says in its regulations that the privacy right is extinguished at death. So if you pass away, then the information that the school maintains is no longer protected, can be released to third parties. Because a privacy right generally only applies while you're alive. That's consistent with most other privacy rights. So in Cable News Network, they were determining, the Ohio courts were determining whether or not 3319-321, Ohio's Student Privacy Act, prevented the school district from releasing records of a deceased student, former student. And this case related to the Dayton shooting in 2019, I believe was the year. And in Dayton, a student by the name of Connor Betts killed 9 people and wounded 17 people outside the Oregon district in Dayton. And he also died. And the Cable News Network was requesting his education records from the district. And the court said, surprisingly, that the Ohio law doesn't have an exception for death, so that school could not release the education records of Connor Betts because the Ohio law doesn't make an exception like FERPA does for death. So again, the school did not release the records. That's interesting. So that's really, it's always been considered that the Ohio law is just really a parallel of the federal law, but in that case, they went a step farther and said there's a protection even beyond death. So HIPAA, this is a little bit confused sometimes in school districts. If FERPA applies in a school district, then HIPAA does not apply. Now we're talking about K-12 schools here. So, if a school maintains a medical record, so let's say you provide it to them, or there's some information from the school psychologist that could be considered a medical record, wherever FERPA applies to an agency like a school district, HIPAA does not apply. So another example would be immunization records are arguably medical records. Counseling records are arguably medical records. But you can't invoke HIPAA in an agency where FERPA applies. But FERPA does protect those records. So they are considered education records because they have information pertaining to a student and they're maintained by the district. So they are equally protected under FERPA where they would have otherwise been protected by HIPAA. HIPAA only applies to healthcare providers. That's the definition. That's just an important distinction to understand. But it is largely the same protection for education records under FERPA as it is medical records under HIPAA. Some recent developments, sharing information with the health department fell under the health and safety emergency exception during COVID. So diagnoses, COVID positive students, that information during the COVID outbreak, during the pandemic was shared with the county and sometimes state health departments. That was a medical record maintained by the district, covered by FERPA, but there was an exception for health and safety emergency, limited in scope to the student name and just that record. That doesn't mean they can share the entire education record with the health department, only that record that's needed to address the health and safety emergency. Video recordings in general. So this comes up a lot again during incidents. So let's say there's a video down the hallway and that video shows just students walking by, or a video in the cafeteria. It just shows students doing what they do in the cafeteria, eating lunch, mingling and hanging out. That's not an education record for any of those students. It's actually a public record because it doesn't document anything other than an observation of what's happening in the bus or in the hallway or in the cafeteria. That's just a public record, doesn't document any particular student. However, as soon as an incident happens, so a fight, or someone, food fight breaks out, someone's throwing food, and those students get disciplined, student gets disciplined, it becomes evidence and an education record for those students, which means for any of the students involved, them and their parents have a right of access to the record, even if other students are involved and disciplined for the same incident. That doesn't mean you get a copy, that you receive the actual recording, but most schools handle it by allowing you to come in and view the video so that you can view the education record or what happened with your own student. A lot of times schools will say, we can't show you that because other students were in there. Well, if they're just in there and they're not being disciplined, then it's not an education record for those students. And if they are in the video and being disciplined, as long as your student's one of them that was disciplined or is pending discipline for an incident, then you have absolutely a right of access to view that video. And then Zoom observations we talked a little bit about during COVID. Viewing, hearing what's going on in the classroom is not necessarily an education record.
I was just going to pop in and say there's some questions in the Q&A.
Okay, I think that takes it to the end anyway. Let me check.
Oh, yeah. Perfect.
Yeah. So let me run through the questions here. So for the consultant case, permission was granted for the school to evaluate, as the family was told school staff were qualified to evaluate and treat. However, the family was caught off guard to find out a month or so later that the school hired a random consultant. That's a problem, I think. It really is. You should know if a third party is going to have access to your records. And they will probably argue that it's a contractor with a legitimate educational interest. But, if you just consented to the school evaluating, then they should be, they should get consent from you to share it with a third party contractor, to share any education records with a third party contractor. Yeah. If a classroom teacher inserts the name of another student in an IEP, is that a HIPAA or FERPA violation? That happens a lot.
A lot. A lot of copy and pasting, unfortunately, I think, or auto saving goals and they pop back in there. Yeah.
It really depends. I think it can be, if they're just changing the name out, and they forget to do that and they send like the actual IEP of another student. Yeah, that's, inadvertent, but probably a FERPA violation. Now, if they just accidentally leave the name in for another student in one section, so you're not really gleaning any information about the student, or you don't see their entire IEP or 504 plan, then probably not. And that's one of those situations, well, even if it was a violation you filed with the U.S. Department of Education, they're going to say, do they have a pattern or practice of doing this? And if they say, no, this was a mistake, then they're just going to dismiss it. So it's whether or not the school has a policy or practice or pattern of engaging in the same type of violations, or it's kind of their policy to do so. But it can be. And we've had some very upset parents who, they get an IEP with another student's name on it, or, the parent with the other student gets upset that their name was on an IEP. One thing it does indicate is that other student whose name was left on there has an IEP, so it is confidential information, or it should be. So it is a problem, but as long as it's not a practice or a policy of the district, I would generally just say, you messed up here, try not to do that again. If a school gets reimbursement from Medicaid for services provided to Medicaid recipients, are they obligated to comply with HIPAA in addition to FERPA? I don't know the answer to that. I would think, I don't know, but I just know, generally speaking, that where FERPA applies, because it largely applies to the same records, anything that would be considered a medical record under HIPAA would be covered under FERPA, which again, so they've kind of made the decision, if HIPAA would apply, but FERPA applies too, then FERPA applies. So my guess is that they may have been covered because they receive reimbursement for Medicaid, but if FERPA applies, then HIPAA does not. That is definitely a question for school council. There's probably some nuance in there. But that's my guess, and I'm not entirely sure. And Rachel just clarified that you know, this is another student who receives special education services. Yeah, if that is a, you know, if it continues to be a problem, yeah, it absolutely is a problem, because you're revealing that a student is receiving special education services when that really shouldn't be revealed. But it, you know, for an inadvertent slip, you know, you just identify that it's a violation, and they shouldn't continue to do that. And so that, yeah, that's the end of the presentation. Let me see if and we're glad to open it up for any other questions. We have about 6 minutes or so. If you have questions related to FERPA or not, we can do our best to help you out. Me and Danielle can put our heads together.
And Renee just popped on, so Renee can jump in. When they were talking about the medical records, I did have a thought, or no, the IEP. I had a thought. You know, when you're in a Zoom meeting and they're presenting and you see everyone's names on the left side of that same goal screen, would that be a violation of FERPA, seeing everyone's names who have special education services?
Oh, who has special education services?
You know, like when they share the same goal screen and it shows all of their caseload on the left hand side because they don't minimize it.
Oh yeah, that they shouldn't do that.
No, they shouldn't. I just the thought popped to my head, like, I wonder if that's a FERPA violation.
Yeah, because then it's really recording what students receive special education services. Yeah, they should,
Right.
should know better than that.
Yeah, I see a lot.
Now, if you're, I thought you were going to ask the question, if you're in a classroom and the class list pops up there, keep in mind, you know, the class that you're in is directory information. So unless you've opted out as a parent, you know, that stuff the school can disclose, because again, it's in the, you know, it's in the directory they send out for the elementary school. It's in the yearbook if they have a yearbook. You know, all that stuff is directory information. But if it's students who are on the, you know, on the special education caseload, then
Yeah.
you know, that's problematic.
Yeah.
Well, unless there are any other questions, that'll be it for the presentation. And then anyone who has an individual guidance session, we start our first one at 1 o'clock. It'll be with me, Danielle, and Renee all together. And if you, I'll drop the link in the chat box one more time to sign up for the next sessions. Ooh, I saw another. Oh, that's it. Bear with me 1 second. You can use that link right there to sign up for any of the other workshops in the series. So thanks, Danielle. Thanks, Renee. And thanks everyone for attending.
Thanks.